Okay, in today's presentations, I am presenting relevancy of admissions by parties in civil proceedings. Hmm. Here we have to see from sections 17 to 23 of the Indian Evidence Act. Here, these provisions provides about the related provisions of relevancy of admissions, specifically in civil proceedings. But one concept you have to remember under the concept of the admissions here, confessions of and accused persons also included. That's why the general provisions of the admissions of parties under the Indian Evidence Act. It is from section 17 to 30. Here, specific provisions in civil proceedings, it is from 17 to 23, and for the confessions of accused persons in criminal prosecutions, the related provisions, it is from section 24 to 30 of the Indian Evidence Act. At first, you have to clarify about this concept. Now, a basic introductions of the admissions. What is the admissions? It really means here, if a statement is made by a party in civil proceeding, it will be called as admission. Whatever the parties made a statement in civil proceedings, it is called an admission. Whatever the admissions of the parties related with the civil matters, related with the civil dispute, that is, it comes under the concept of the admissions. Here, the expression admissions uh, means voluntary acknowledgements of the existence or truth of a particular fact. Here, this section 17 says that it will be relevant only in the circumstances mentioned in the Act. That is the Indian Evidence Act. Such circumstances are mentioned in section 17 to 30 of the Indian Evidence Act. Yeah. An admission is genus, but the confession is a species. Because all confessions is admissions, but all admissions is not confessions. You have to remember about this. That's why the admission is the genus, and the confession is the species. That is the basic introductions. Why the provisions of this is of the admissions of parties are included in the Indian Evidence Act. Here, at first is section 17. It provides about the definitions of the admissions. Here, this section points three basic things. Here, in the first, it defines admission in terms of a statement which may be oral or documentary or in electronic form. And secondly, this section says that an admission will be relevant only if it is made by any of the persons specified in the Act. The list is to be found in section 18. And secondly says that whatever listed in this section 18, that these particular persons, whatever they have been made as statements, they will be produced as an evidence in the court. Whether their admissions will be admissible or not, it depends on the justice. That is, but a list of persons, it is given under sections 18. And thirdly, this section says that it will be relevant only in the circumstances mentioned in the Act. Such circumstances are mentioned in sections 17 to 30. It is, section 17 provides about this. Here, about the definitions of an admissions, this section says that an admission is a statement which suggests some inference as to the existence of a fact, an issue or a fact relevant to the issue. Admissions, that means whatever is statement by the parties to the relevant facts and issue or disputed fact, whether it is relevant or not. It is whether it is admissible in civil proceedings or criminal proceedings or not. That is the concept of the admissions of the parties. That is, whatever the statements in relation to the civil prosecutions, it comes under the admissions, and whatever the statements of an accused persons in search of a crime, it comes under the concept of the confessions. And first you have to clarify about this yourself. Now, section 18, it provides about the admission by party to proceeding or agents by suitor in representative character, by party interested in subject matter, by person from whom interest derive. Here, section 18 lays down the list of persons whose admissions constitute evidence against a party. Here, the effects of section 18, 19, and 20, when put together, is that the admissions of following parties become relevant. Here, number one, parties to the suit, and secondly, agents of parties, and thirdly, persons occupying a representative character, and statements of third parties. That is, and this category will include the statements of the following parties. That is, persons having pecuniary or proprietary interest, and secondly, persons from whom the parties derive their interest, and the persons whose position is an issue or is relevant. And persons expressly referred to. Here, these admissions of parties will be relevant in civil proceedings. Sections 18 of Indian evidence say it is expressly given that whatever these persons, whatever these parties, they have made statements in relation to the relevant facts and issue and disputed facts regarding the civil subject matter, then their statements will be relevant. That is. Here, now the section 19. Yeah, admission by persons whose position must be proved as against party to suit. Section 19 provides about this. Yeah. Section 19 deals with the statements of persons whose positions is in issue. Yeah, though they are not parties to the case. Section 19 provides that although some particular persons or parties they may not be parties to the particular case, but their positions, whatever their positions, it will be relevant. That is, whatever the position is an issue. That is, here you see one illustration here given. A undertakes to collect rents for B. B sues A for not collecting rents due from C to B. A denies that rent was due from C to B. A statement by C that he owed B. Rent is an admission and is relevant fact against A. If A denies that she did owe rent to B. Yeah. Yeah, regarding the positions of the money lender. Here, if the money borrower, if he says that I owed some amount of rupees to this particular person. Now, whatever the principal and the agents, they have been disputed about whether the agent have been collected the amount or not. Here, if the money lender, that is the borrower, money borrower, if he admits that I owed some amount to these persons, then these positions of the money borrower, that is, the statements of this money borrower will be relevant in this disputed facts between the principal and the agents about the collecting of the rent. Okay. Now the section 20. Here, this section provides about the admission by persons expressly referred to by party to suit. Here, statements made by persons to whom a party to the suit has expressly referred for information in reference to a matter in dispute are admissions. Here, illustration you see, the question is whether a horse sold by A to B is shown as says to B, go and ask she. She knows all about it. She's statement is an admission. Yeah. If the parties to the contract or if the parties to the agreements, if they have referred some third persons, yeah, In these illustrations, the subject matter is the selling of the horse. If the owner, that is the seller, if he expressly refer the third persons, then go and ask to see whether my horse is sound or not. Here, whatever the third persons, he will make statements regarding the whether the horse is sound or not. These statements of the third persons will be relevant in the civil proceedings. That is, if some dispute arises between these two parties, between the seller and the purchaser. Here, now the section 21, proof of admissions against persons, making them and by or on their behalf. That is, this section lays down the principles as to proof of admissions. This section is based upon the principle that an admission is an evidence against a party who has made these admissions, and therefore it can be proved against him. He himself cannot prove his own statements. This section says that whatever the statements made by the parties regarding the civil subject, these statements can be proved against these persons. Yeah. Suppose in case if I said that I have to owe 1 lakh rupees to some persons. Whatever I have made statements that I have owed 1 lakh rupees to some particular persons. These statements can be give evidence against me. This can be proved against me because it is my statements, but I cannot prove it myself. The other person can prove whatever I have made statements. This sections 21 provides about this. Here, now the sections 22. Here, when oral admissions as to contents of documents are relevant. Here, oral admissions as to the contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such documents under the rules hereinafter contains, or unless the genuineness of the documents produced is in question. This section 22, it says that here the parties, they have to right to produce the oral admissions as to the contents of documents if they are entitled to give the secondary evidence. That is, without this they cannot be produced the oral evidence, that is, about the contents of the document. Here, now the sections 22 clause A. It provides about when oral admissions as to contents of electronic records are relevant. Here, oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produces in questions. Whatever the genuineness of the electronic records, if it is in questions, then it will be relevant. Whatever the electronic evidence, it will be relevant. Here, electronic records are presumed to be true. No further evidence is necessary in proof of a fact appearing in record, in such a record. There is presumption of law that all the electronic records is presumed to be true. That is here. Now the section 23, that is the last sections of the admissions of parties in relation to the civil proceedings. Here, uh, admissions in civil cases when relevance, this section provides about the admissions in civil cases when relevant. Here, in civil cases, no admission is relevant if it is made either upon an express conditions that evidence of it is not to be given or under circumstances from which the court can infer that the parties agreed together that the evidence of it should not be given. Yeah. This section provides about the compromise between the parties of the litigations. If the parties they have expressly agreed compromise on some subject matter, then the evidence of this settlement should not be produced in the evidence. Then whatever they have made admissions at the moment of the compromise, whatever they have made statements at the moment of the compromise, these statements of the parties will not be relevant, cannot be permitted to produce in the proceedings, in the civil proceedings. Yeah, and in explanation clause you have to see nothing is these sections shall be taken to exempt any barrister, a pleader, attorney, or a wakil from giving evidence of any matter of which he may be compelled to give evidence under sections 126. Yeah, explanation provides that here the barrister, pleader, attorney, wakil, they can also be uh, settled under the concept of the compromise between the parties, and their statements under the compromise of the subject matter under the relevant facts and issue. Whatever they have made admissions, their admissions also will not be relevant and cannot be produced as an evidence in the court. Whatever they have made admissions at the moment of the compromise between the parties. Section 23 expressly provides about this. Here, now you see the difference between the confession and admissions. Here, we have to know about the difference also between the admission and the confessions. Here, all confessions are admissions, but all admissions are not confessions. You have to remember about this. Here, number one, if a statement is made by a party in civil proceeding, it will be called as admissions. On the other hand, if a statement made by a party charged with a crime in criminal proceeding, it is called as a confession. Now, number two distinctions: the expressions admission means voluntarily acknowledgments of the existence or truth of a particular fact. On the other hand, the expression confessions means a statement made by an accused admitting his guilt. If a person accused of an offense makes a statement against himself, it is called the confession. Now the number three distinctions. An admission is the genus. On the other hand, confession is a species. And hence all the confessions are admissions, but all admissions are not confessions. Number four distinctions. The term admission is applicable to statements, oral or in writing, made by a party in civil side. In civil case. Here, but the confession is the term for admissions of guilt, that is the offense, made in the criminal prosecutions. Number five distinctions. An admission is not conclusive proof of the matters admitted, and is always rebuttable. But a confessions, if voluntarily and free, may in the discretions of the judge or magistrate, by itself be accepted as conclusive proof of matters confessed, and is alone sufficient to warrant a conviction. What about the confession made by the accused persons? If it is voluntarily made by the accused persons, and if it is free, there is no concept of the inducements, threat, fear done by the persons in authority, by the police official. Here, under the concept of the voluntarily and free confession by the accused persons, based on these statements of accused person himself, the judges, the court, or the judiciary, they can sentence for convictions of these accused persons. But the admissions is not the conclusive evidence. Here, number six distinctions. And admissions may be proof by or behalf of the persons making it. What about the admissions in civil proceedings? It can be proof against the persons or on behalf of the persons who have been making these statements. But the confessions always goes against the persons making it. But the confession always goes against the persons making it. And the seven number distinctions. An admission may be made by an agent in course of business. Yeah. What about the admissions in civil proceedings? It may be made by the agents under the concept of the agency, that is, in course of the business. What about the agents? Under the authority conferred by the principal, whatever he have been made statements, it will be relevance in this civil dispute. And while an agent can never make the confessions of an offense against a co-defendant. Yeah. But under the concept of the confessions, here there is no concept of the agency. Here an agent cannot confess against the co-accused. There is no concept of agency regarding the commissions of the crime, in the prosecutions of the crime. Here, admissions are number of distinctions. Admission by one of the several defendants in suit is not evidence against other defendants. Yeah. In case of the civil proceedings, admissions of the several defendants, that is the co-defendants. Here is not evidence against the co-defendants. Here, but in case of confessions made by one or two or more accused jointly tried for the same offense can be taken into considerations against the co-accused. But in case of the confessions, if the accused persons have been jointly tried in the same offense. Here, in these cases, whatever the one of these accused persons have made confession. This confession can be used as the evidence against the other co-offender, co-accused, because they have been tried under the same offense jointly. This come under the concept of the common intentions, common object, if they have been committed the crime. That is, in these cases, whatever the one accused persons of the several accused persons jointly tried for the same offense. Based on this co-accused persons' confession statements, the judge, magistrate court, or judiciary, they have authority to sentence. If the guilty is established by the court, they can order for the convictions of these accused persons. That is, here, after this, we have clearly discussed about the concept of the admissions and the related provisions of the admissions under the Indian Evidence Act. And last part, we have discussed the distinction between the admissions and confessions. We have clearly discussed. I think we got the clear concept. Okay, that's all.